My name is Jeff Lewis, National Director of the Patriot Coalition. Our General Counsel, Mr. Richard Fry, is going to go through the presentation, and at some point I'm going to get Stewart back in here on the audio portion of this. Mr. Fry, floor is yours.
Thanks everybody for attending. We're sorry about the difficulties. We did do a prior test and had it up and running for a couple hours, and then didn't start having trouble about half an hour or so before. So I don't know how to explain that. But anyway, here we go. Tonight we're going to be talking about the NDAA. The NDAA, we're talking about the National Defense Authorization Act for fiscal year 2012. Our first question is the NDAA bad? These are going to be a series of questions that we need to answer. Does the NDAA simply affirm existing national defense policy, or does it create new national defense policy? Was it the intent of Congress to establish that America should be treated as part of the battlefield? Does the NDAA authorize waging war on Americans in the United States? Does the NDAA apply to U.S. citizens? Does the NDAA undermine your constitutional rights as a citizen? If the NDAA applies to U.S. citizens and undermines your constitutional rights, is the NDAA bad? No. I'm sorry for the delay. We're having a little time delay. The purpose of the NDAA is to fund our troops and our national defense policies, and that's a good thing. Does the NDAA create new national defense policy? In Section 1021 of the NADA, it indicates that it affirms the authority of the Armed Forces of the United States to detain covered persons pursuant to the authorization for use of the military force. In subsection G again, it says Congress affirms the authority of the President pursuant to the authorization for use of force. Subtitle D, Counterterrorism 1021. The authorization for use of armed forces of the United States to detain covered persons pursuant to the UMF. What we're seeing now is the UMF, Authorization for Use of the United States Armed Forces. It was signed by the President on September the 18th, 2001 in follow-up and in response to the terrorist attacks. It indicates the President's authorized to use all necessary force against those nations, organizations, or persons he determines planned, organized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such individuals. This is the 2001 Act that the NDA refers to. The UMF set up a national defense policy to seek retribution against those involved in the attacks of September 11, 2001. The authority granted in the AUMF was retrospective and tied solely to the attacks of September 11, 2001. It was a backward-looking policy. It was going to go after those that committed the terrorist attacks or were involved in those. This is a targeting profile, simplified targeting profile for what the AUMF provides. And again, nations, organizations, or persons, and notice it's all past tense, that planned, authorized, committed, aided, or harbored the terrorists who attacked on September the 11th, 2001. It's all tied to September the 11th, 2001, and those that were involved in the planning and execution of that attack. It's a retrospective policy. Does the NDA simply affirm policy, or does it create new policy? Slide. Okay, this is the NADA. This is Section 1021 that says it's affirming the authority of the AUMF, the 2001 AUMF. The first targeting profile is B1, and it says a person who planned, authorized, committed, or aided in the terrorist attacks of September the 11th, 2001, or harbored those persons responsible. This is a side-by-side of the AUMF and the NDAA N21B1 targeting profiles. On the left is the AUMF targeting profile. On the right in blue is the NADA 2012 NADA targeting profile. Notice they're both tied to September 11th. They're both related to those who planned, authorized, committed, aided, or harbored. So in terms of the B1 of the NADA, it does affirm the 2001 authorization for use of military force. No problem so far. The 1021A B1 affirms the national defense policy of the United States. But remember, the AUMF had only one targeting profile, but the NADA has two targeting profiles. What does 1021, the second target profile, provide? This is our second targeting profile within the NADA. A person who was, past tense, a part or substantially supported Al-Qaeda, the Taliban, or associated forces that are, notice we just changed tense from past, now we're present, that are engaged in hostilities against the United States or its coalition partners, including any person who has committed a belligerent act or has directly supported such hostilities in aid of such enemy forces. It's different than the AUMF of 2001. This slide shows a complete targeting profile for the 2012 NADA. On the left-hand side, on the light blue, we see the 1021B1, which is equivalent to the authorization for use of force of 2001. On the right, we see an expanded targeting profile for under 1021B2. So as we can see, the NADA did more than simply affirm, as it represents. It did more than affirm the targeting profile of the 2001 authorization for military force. And most of these words are not defined. They're left up to the administration to fill them in as to what they mean. So the 1021B2, it creates a new national defense policy in that it expands the targeting profile beyond that of the 2001 authorization for use of military force, which it said it affirmed. It expands the countries being protected. Now it's also the coalition partners in addition to the United States. The time frame for which hostilities are organized goes beyond retribution for the 9/11/2001 attacks. It's basically an unlimited and moving forward. And it goes from a policy of retribution for those who made the attacks of 9/11 to a quote-unquote war on terrorism. Also, this slide is telling us the definition of terrorism. And as you can see, terrorism is not a nation, it's not a person. What it is, it's a technique. So to have a war on terrorism, I can go ahead and change the slide when you want. The war on terrorism is like saying we're going to have a war on military maneuvers, or we're going to have a war on marching, or we're going to have a war on some other philosophy. It's almost nonsensical. And what has happened now is that the rhetoric of terrorism, if you remember right after the 9/11 attacks, George Bush said we are having a war on terrorism. But we didn't. The national policy was a policy of retribution against defined definite people over a definite time frame. Now the law has caught up to the rhetoric, and what the 2012 NADA does is establish that we're having a war on terror. Our next question, was it the intent of Congress to establish that America should be part of a battlefield, and does the NADA authorize waging war on Americans in the United States?
Saying that you have the option to make sure that you can put intelligence gathering as the top priority. So this, as you've identified and talked about, is a very reasonable compromise. And as you know, my colleague from South Carolina, I would have actually liked to seen this go further. But this is very important that we bring this forward.
And I would add that Senator Lieberman would have gone further than you, and nobody I respect more than Senator Lieberman, but trying to find a balanced way. So in summary here, 1032, the military custody provision, which has waivers and a lot of flexibility, doesn't apply to American citizens. 1031, the statement of authority to detain, does apply to American citizens, and it designates the world as the battlefield, including the homeland. Are you familiar with the Padilla case? That is a federal court case involving an American citizen captured in the United States that was held for several years as an enemy combatant. His case went to the Fourth Circuit. The Fourth Circuit Court of Appeals said an American citizen can be held by our military as an enemy combatant, even if they're caught here in the United States, because once you join the enemy forces, then you present a military threat, and your citizenship is not a sort of a get-out-of-jail-free card. That the law of the land is that an American citizen can be held as an enemy combatant. That went to the Fourth Circuit, and that, as I speak, is the law of the land.
That's right. That is the law of the land, and that's what's reflected in this provision.
Again, this is what we see here is Senator Graham making the point that the entire world is the battlefield, including the United States. And he made that point, as did other proponents of this bill, over and over. When we watch the Senate floor debate on C-SPAN relating to the Conferee report, he likewise made that same statement. This bill will make the United States a battlefield for the first time, et cetera, et cetera. And so even though it's not expressed directly in the NADA, congressional intent is well established that the purpose was to make America a battlefield, and that, of course, is for purposes of applying the law of war on the United States of America and its citizens. The fictitious designation of the United States as a battlefield allows for the application of the law of war, applies to all battlefields to the United States. And all of our veterans out there can tell you the person that's in authority and control of the battlefield is the commander-in-chief. It's the military that does that. It, in essence, puts the president in charge as the commander-in-chief, not as the chief executive officer of the United States. Does the NADA apply to U.S. citizens? And again, I think as many of our veterans can tell us, the military has control over the battlefield, and it doesn't matter who's on that battlefield. They have control. Okay, this is Section 1022, military custody for foreign al-Qaeda terrorists. Something you need to keep in mind, too, is these captions are not part of the law. They're used to assist people to find what they're looking for within the law. The fact that this caption says foreign al-Qaeda is basically meaningless unless it's verified in the body of the law itself, which it is not. Okay, this is 1022A1. Except as provided in paragraph 4, which is a national security waiver, the Armed Forces of the United States shall hold a person described in paragraph 2 who is captured in the course of hostilities authorized by the AUMF, again, the 2001 AUMF, in military custody pending disposition under the law of war. And, of course, we know that this is a misrepresentation because 1021 B1 or B establishes a much broader targeting profile than B2. The requirement in paragraph 1 shall apply to any persons whose detention is authorized under Section 1021 who is determined. And so it's taking the total target profile of 1021 and it's going to add some requirements. This is going to be a smaller targeting profile. It's going to be a subset of one. And again, it says the Armed Forces of the United States shall hold the person described in paragraph 2 who is captured, etc., in the course of hostilities authorized by the AUMF. Shall hold. The requirement requirement they're referring about is the requirement that says shall hold. Not all of 1022, it's that particular requirement, shall hold. What does shall hold mean? Shall hold means must hold. In other words, the military has no discretion. If they capture someone that fits the sub-targeting profile of 1022, they have no discretion. They must hold them. United States citizens. The requirement to detain a person in military custody under this section does not extend to citizens of the United States. Many of our politicians hang their hat on this, including Colonel Allen West. He reads this section in a YouTube presentation to the Tea Party group and says, see, it doesn't apply to U.S. citizens. What doesn't apply? The requirement to detain doesn't apply. Removing the requirement, shall hold, means that the U.S. military may hold U.S. citizens. It does not prohibit U.S. citizens from being detained by the U.S. military under Section 1022, and in fact, it doesn't apply to 1021. All right, looking at NDAA Section 1022A2, covered persons, and this goes and shows the further restrictions. This is the targeting profile itself of 1022. Shows the further restrictions that are placed on 1021 to derive the sub-targeting profile of 1022. And again, you'll note that many of these terms are not, all of those terms are not defined. None of those terms are defined. This is a depiction of the 1022 targeting profile. It starts out with all non-citizens which must be held under the provision shall hold. Then there's a subset within 1022 that says U.S. citizens may be held, but they are not required to be held. The military is not required to hold them, but has the discretion to hold them.
And Richard, I want you to explain that one more time, because this is the biggest, one of the biggest parts of what members of Congress, those that are knowingly and unknowingly perpetrating a lie, that it doesn't apply. This is it right here.
Okay, and there's two things you have to remember. Number one, even within 1022, the exclusion, all it does is it means that the military does not have to hold, but may hold U.S. citizens. The plain language of that is they may hold. All non-citizens that fit within the targeting profile of 1022 must be held. Must be held. But you also have to remember, the exclusion of 1022 only applies to 1022. It doesn't apply to the authority to detain under 1021. So the indefinite detention provisions of both 1021 and 1022 absolutely apply to U.S. citizens. And you have Senators McCain, Graham, Levin, who expressed that. That's what they wanted. And President Obama, in his signing statement, acknowledged that the NADA gave him the authority to indefinitely detain U.S. citizens. But he insisted that he wasn't going to do that. And in fact, he was the one that insisted that the provisions allowing him to detain be placed and maintained in the NADA. And we're going to see a clip on that.
And I'm wondering whether the senator is familiar with the fact that the language which precluded the application of Section 1031 to American citizens was in the bill that we originally approved in the Armed Services Committee, and the administration asked us to remove the language which says that U.S. citizens and lawful residents would not be subject to this section. Is the senator familiar with the fact that it was the administration that asked us to remove the very language which we had in the bill which passed the committee, and that we removed it at the request of the administration, that would have said that this determination would not apply to U.S. citizens and lawful residents? I'm just wondering, is the senator familiar with the fact that it was the administration which asked us to remove the very language, the absence of which is now objected to by the senator from Illinois.
I'm familiar now because the senator from Michigan has shared that fact.
Okay, this was Senator Levin, who was a big proponent of the Ndaa bill. And what he's trying to clarify for one of his fellow senators is, initially, even in the Senate bill, there was a provision restricting the detention of U.S. citizens. But at the insistence of the administration, the president, that was removed. And when he talks about 1031, he's talking about the bill that the Senate approved. There was one bill approved in the House, 1564, I believe.
No, 1540.
40, I'm sorry. And in the Senate, 1867. And so that's why you see a difference. The bills went to a conference committee, the House bill, the Senate bill, and they were merged together. And what came out was under the House bill number. So that's why you see the provisions that was in Senate Bill 1031 are now in 1021 of 1540. Okay, again, this is under 1022B is what we're talking about. The requirement to detain persons in military custody under this section, in other words, we're talking about 1022. It does not apply to 1021. What we are seeing now is the total target profile of the Ndaa. On the left, the light blue square is the B1 target profile, which is virtually identical to the 2001 Act that the Ndaa is supposed to be affirming. In the green box, what we see is the expanded targeting profile that was added under the Ndaa. And then in the light blue circle and the yellow circle, we see the separate targeting profile, the sub-profile of that of the 1022. And you can see that it does exclude U.S. citizens from the requirement that they be detained and leaves it in the military's discretion to detain. But all of the citizens in the green box and the light blue box are still subject to detention by the U.S. military. And the point that should be made there is, even if the senators like Senator Allen was correct, that 1022 prohibited the detention of citizens, there are many, many citizens outside 1022 that can be detained. That's the point that needs to be made. Does the Ndaa undermine your constitutional rights? I think we're all getting pretty close to being able to answer that question. Congress has established the principle that America is a battlefield while arguing over how to apply the law aboard a citizen. And both the opponents and proponents of Congress agreed that this made America part of the battlefield. What they disagreed on is what the current law was and whether the Ndaa provisions complied with the Constitution or not. That was really the argument. It was a brilliant plan to insert congressional intent in an argument that had no significance to the citizens' liberties, if you will.
All right, and have you, this was a particular slide that Stewart was wanting to make a comment on now, and I'm not going to make it for him, but we're going to get Stewart back in here once we get through the formal part of this presentation, and he's going to talk about this issue some more.
The Ndaa authorizes the capture in the United States without an arrest warrant. It says in the Ndaa itself that the military, it talks about the capture or arrest.
And when they say, I want my lawyer, you tell them, shut up.
Your time
Don't
is
get a
expired.
lawyer. You're an enemy combatant. And when they say, I want my lawyer, you tell them, shut up.
Your time is
Don't get a
expired.
lawyer. You're an enemy combatant.
Yeah, I'm sure that our founding fathers heard something like that when they were told to shut up, that they were a traitor to the crown. Okay, here's another deception within the bill itself. Section 1021E states that nothing in the 1021 section affects any existing law or authority relating to detention of any person who is captured or arrested in the United States. One thing is that by the use of the term captured, it's a term of art relating to taken into custody by military.
arrested is a term of art relating to be taken into custody by the civil authorities, by law enforcement. So they're anticipating the military involvement in the United States here. And clearly this thing is incorrect. It's a misrepresentation because it does affect existing law of detention, because as we've seen, at the very least, the 1021b2 profile expands what was the existing law on who could be detained. It expanded the number of citizens potentially exposed to being captured by the military. So this is a false statement. Section 1022A1 states that the U.S. military shall hold any person who is captured in the course of hostilities authorized by the AUMF. Again, we're talking about captured, the military taking custody of those people. This section, it's in 1021C, the disposition under law of war. The disposition of a person under the law of war, as described in subsection A, may include the following. And the law of war is that law by which countries wage war against one another or other entities. So the very inclusion of this indicates they're waging war. And now they're going to talk about applying the law of war on those captured, which would include U.S. citizens. What we see now is the parts of the Constitution that are affected or nullified, if you will, attempted to be nullified by the 2012 Ndaa Act.
Yeah, and I'd like to insert something here. This is just the biggie stuff. You could probably go into even more, but in the research that Richard, Stewart, and I did, and we've spent hundreds of hours developing the resolutions that are being introduced at state legislatures, county commissions, sheriffs across the country, and that's what we used to develop this PowerPoint presentation. There's probably more, and what I tell legislators, or every public servant I run into, that says they're kind of busy, or it's not my job, this violates easily over half of the Bill of Rights. And you should ask them, what are you doing that's so important that you don't have time to defend our God-given unalienable rights? That is your job one.
Yeah, let's go ahead. Here's our summary. I know somebody said that this is just a big misunderstanding, and it is. The terrible misunderstanding that we're having is that our elected officials don't understand the Constitution and that it's a permanent document. It's our foundation document. They think it's maybe a suggestions for how they should run the government. Is the not a bad? Yes and no. It's good that we are funding our military and our national defense policy. We need that for a strong defense of the country. But to destroy the Bill of Rights in the process is very bad and unnecessary.
Richard, I've got to interject. I just saw in the chat a question. What's with this skull and crossbones? And I know a lot of folks have issues with the skull and bones, but there's no skull and bones here. The skull and crossbones in the Intolerable Acts logo is from a 1765 Stamp Act protest, which was, the Stamp Act was not really considered one of the Intolerable Acts, but it was a cartoon protest, and that's the actual Bill of Rights behind it. Okay, Richard.
Does the NDA simply affirm existing national defense policy, or does it create new national defense policy? We see that it does both. It basically says it's affirming and funding national defense policy. But in reality, what it does is it creates new national defense policy in that it establishes a war on terrorism, which goes exponentially beyond that of the prior policy of retribution for 9/11. Was it the intent of Congress to establish America to be treated as part of the battlefield? Yes, it was. Not everybody in Congress agreed with it. Not everybody in Congress wanted it. But they all basically agreed that's what it was doing. So that's what we really have now. Does it not authorize waging war on Americans in the United States? Absolutely it does. It will treat American citizens that fit within that profile, even if they are within the United States, under the laws of war. Does it apply to U.S. citizens? Of course, we've seen it several instances now. It absolutely does apply to U.S. citizens, without doubt. Those who try to tell you otherwise have not read the law, or they are trying to deceive you. Does they undermine your constitutional rights? Absolutely, we've seen that. 14 separate provisions of the Constitution and the Bill of Rights are being wiped away by the NADA. So the question is, if the NADA applies to U.S. citizens and undermines your constitutional rights, what do you do? And what should you do about it?
And I want to interject in here, Richard. When at the Patriot Coalition, when we first got a wind of this, we heard that some senators were, or out in Montana, there was a recall effort that the OathKeepers were involved in, because both Montana senators voted for the NDAA. And we've worked with several OathKeepers, including Stewart and others on the board, for the past few years on different things. But I talked to Richard about this, and our executive director, and we decided that we needed to take this on, on top of everything else. And we reached out to Stewart. That was when we reached out to Stewart about us working together and creating the Intolerable Acts. And Stewart came out to Kansas for the 4th annual Kansas State Sovereignty Rally that our General Counsel, Richard, who's been talking through this presentation, has been hosting and working with groups in Kansas, with his group, the November Patriots. And it was the Saturday event in the flyer for that I decided that the Intolerable Acts was the best thing to call it. And that's where the name came from for the project that we're working on with the OathKeepers. All you, Richard.
All right, here we go. This is basically the plan of attack that we have on the NADA and the other Intolerable Acts. And what we have is the Patriot Coalition, OathKeepers, and some other national partners at the top that are doing the research, developing the ground strategy, and the entire objective is to empower the state and local organizations so they can do what they need to do to get this changed. So we will have a state coordinating organization. In Kansas, it's November Patriots. In North Carolina, it's a Patriot Watchdog. And they will coordinate and send information down through the other state and local groups. And again, like in Kansas, for instance, we have the Patriot Freedom Alliance as part of that network, and the Beaufort Patriot Tea Party in North Carolina that are at work, getting the information out to the grassroots. And then, of course, that filters down to we the people. So that's kind of the educational process and the organizational process that we have.
Now, Richard, you got to get that right. If you say Beaufort, I have enough problems people thinking I'm from South Carolina already, and that's what they call it down there, is Beaufort. It's Beaufort. Thank you.
That's what they told me to say it that way.
Yeah. Go ahead.
So, and this is basically what we're doing at the national level. We're doing the research and analysis that relieves the state parties from having to do it, because, again, we've spent hundreds and hundreds, probably over 1,000 hours at this point, studying this. That relieves them of that burden, and we have some pretty doggone good talent up here on the national level. So we do the research analysis. We get that information out. We're also doing analysis of the federal, state, and local remedial legislation, and then we are developing customized resolutions and legislation for the federal, state, and local level as well. By educational seminars such as we're doing tonight, Stuart's been traveling all over the country speaking in an effort to support the state and local groups, do a media reach out, do interviews, talk radio, to get the word out. What we're finding now, not so much, but certainly initially, is the the federal legislators were simply denying this was a problem. We've had the vast majority of ours in Kansas have voted for this, and they're denying there's a problem. It's kind of like Alan West denies that there's a problem, doesn't apply to citizens. if we get enough people educated, they will be laughed out of town. They will have to stop saying that and have to help, or at least stop impairing our ability to get it fixed.
And what you're looking at here on the screen while we're waiting to get our general counsel and Stewart back is the cover sheet that you'll see on a lot of our state legislator resolutions. And I'm going to skip through that because I know this as well as they do. Up here at the top, this is there's a link to the OathKeepers, to the Patriot Coalition. Both Stewart and Richard's numbers are here, as well as mine, our email addresses. And this quote down here from Daniel Webster, very important one. I'm committed against everything which in my judgment may weaken, endanger, or destroy the Constitution, and especially against all extension of executive power. And I am committed against any attempt to rule the free people of this country by the powers that be. On the back of all of our resolutions, whether it's the state legislators, county commissioners, sheriffs, and there's some of these that are a long version and a short version, on the back of each one of them, you'll see a reference and source documents, and these are not all of the documents that we used in the research and development of these, but it's some of them, and they are custom tailored for your state and your state constitutions. We have all 50 of them, and believe me, it was not easy finding and getting hold of all 50 of them. No matter where you live, if you can't go directly to your state legislator's website and in less than 3 minutes find your state constitution that you can download in a PDF, you need to get on the horn and go see your legislator and tell them to fix it. Some of the, as we were capturing some of these, they had every little article section on a separate page. It's like they don't want you to even have your state constitutions. Pardon me for the bloviating, but that was a real pain.
Tell them where they can find these documents. I don't think we've explained to them where they go to get these documents.
Well, that's where I'm going to the next slide, and you'll see that now. If you go to the intolerableacts.org, and you won't see all 50 states finished yet, but right here, and if you're watching to the screen, you'll see where my mouse is moving over the home page of the Patriot Coalition / OathKeepers project site, the Intolerable Acts Action Center. If your state is not highlighted in blue, it's because nobody has reached out to us from that state requesting one of our resolutions. If you see it's blue, then you can click on your state and it'll take you to the state page. On that state page, you will see the state legislators' resolution, clickable, downloaded PDFs, and some have you'll see some have a long and a short version, and that depends on what the legislators want, what we can get past them. And underneath, and this is not for every state yet because there's a lot of counties. Some states we have every single county in the state already with the resolutions complete for the specific county, for their county. So if you don't see your state, then let us know and we'll get it done, and in just a few days we'll have it. And then if you go to the state page and you don't see all of your counties there, you see a template. That A template means we've got the county commissioner's resolution done, and we've done a template of the first county alphabetically in your state. We're not playing favorites. And in that template, there's only 2 places that you'll need to change anything to match your county in your state. And again, that reference sheet that I showed you before is attached to all of our resolutions. So if you don't see it and you don't want to wait 2 or 3 days for us to get it back to you, you can go to get the A template, and it's highlighted. And these are Word documents on the county ones. And this PowerPoint presentation, let me back up. You see Judge Napolitano here on this video here. There's 3 videos, and I'm going to move it further up to the top. But if you just go down to the 3rd video you see, right above, and it's the 1948 Make Mine Freedom cartoon, directly above that is a link to this PowerPoint presentation. What should you do? You need to educate yourself, your family, and neighbors, your community about the problems with the NDAA. You need to watch the videos, and there's a lot of videos on the NDAA, and there's some more that are coming that we haven't made public yet. Write letters to the editor of your local paper. Reach out to grassroots Patriot groups in your community. Encourage their involvement. And what should you do next once you get educated? Contact your congressmen and U.S. senators. If they voted for the NDAA, find out why. And if you're not sure if they voted for them or not, if you'll get that reference resource sheet off the back of any of our resolutions, it has a direct link to the House and Senate voting records for the NDAA, so you'll know if yours voted for it or against it. And regardless of how they voted, because some were duped into voting for it based on the deceptive language that was in the House Armed Services Committee summary report. So it doesn't matter whether they did it on purpose or not, they need to do something about it. Contact your state legislators, county commissioners, sheriff, and city council. Encourage them to interpose themselves between we the people and a rogue federal government.
What we have then is the black lines here show the direct contact that we are having with our sheriffs in the first instance on these resolutions. And then on some of these resolutions, it requires the person contacted. So if you look at the state legislature, it requires the state legislature to contact the congressional delegations while we the people are doing the same thing. And so what we're doing is we're building some synergy in our efforts, because not only are we doing it as groups and people, but we are having sub-governmental units contacting higher governmental units saying, you need to do this. So your city commission or county commission will do these resolutions and send them to the legislature saying, you need to do this. And then the legislature will send them on to Congress. So that's the way it's supposed to operate. And don't forget about your political parties, put pressure on them as well.
I'm working with my local government in North Carolina. We've got specifically several county commissioners that are putting pressure on our senators, trying to get good feedback on why they did what they did or to get engaged. But we've got it going to be introduced in the North Carolina General Assembly by a founding member of the OathKeepers, Representative Glenn Bradley. Sometime, I think they reconvene on April 23rd. And we've been working and building a support effort on the in fact, you've probably seen, that's the gentleman that's in the Luke video right now when we're not broadcasting live, is the interview I did with Representative Bradley. Also, Representative Charles Key in Oklahoma has already introduced it, and it can't move in the short session if the people don't get behind it, because the leadership, even in the legislatures, are not wanting to do this because they'll say it's not my job. And you need to tell them, you took an oath. If you can't uphold it, it won't be your job. We'll replace you. All right. I'm going to turn this over to Richard and Stewart here, and they're going to start taking some questions in just a second here. But one last update. Yesterday, and I don't know how the hearing turned out, but some of you are aware that Representative Dan Gordon in Rhode Island had introduced a resolution that was crafted by the Rhode Island Liberty Coalition. And they had their judiciary hearing yesterday afternoon, and we submitted formal testimony to the Rhode Island House Judiciary on behalf of the Intolerable Acts Action Center that me and Stewart and Richard put together. And there's also some more legislation that we're working on with Representative Gordon now for when his bill gets to the floor. Patriot Coalition is our parent organization. Please visit rejoinorDie.com. You'll find a lot of stuff there about other usurpations, such as the this 14th Amendment debacle of birthright citizenship, where it comes from. go to the OathKeepers.org, and they've got several other projects, and Stewart can speak better about them. And if you have questions or you don't have a resolution for your state, county, local government, all you got to do is shoot an email to really any of us, to me, Richard, or Stewart. But as far as the resolution request, if you don't have them already, I would appreciate it if you would send an email to solutions@theintolerableacts.org and copy Richard and Stewart on it as well.
No, Richard, go ahead.
Okay. All right, what other questions do we have? The NDA means military can arrest all citizens. This means military can arrest Congress. Here's the problem, is that according to this, the AUMF authorized the president to use whatever force he determined was necessary and appropriate against groups, nations, and individuals that he determined had something to do with 9/11, and now under the AUMF, as Richard pointed out earlier, it's been expanded to other things. It leaves the discretion in the hands of the president, and he's the commander-in-chief. And so, it's highly unlikely that somebody in the military is going to go and do something different than what the president tells them to do. Besides that, I don't think it'd be right to do that. What should happen to them is they should be arrested and tried for treason. But the problem is, because they're all traitors, SOBs, who's going to arrest them? What U.S. attorney is going to charge them? What U.S. marshal is going to go arrest them? So this is the problem we're at. And that's why I think the best response is at the state level. I think it'd be a mistake to look to the military and want the military to step in. That would be a military coup, and that's going from the frying pan into the fire. The constitutional remedy and the lawful remedy under the design of the founders is for the states to stand up, just like they did back in 1798 against the Alien Sedition Acts. And so I encourage you to go read the Kentucky resolutions and the Virginia resolutions about state nullifications and state standing up. Since it's ground zero as a pilot's case against Obama, they can bring all constitutional violators to their knees. I do not agree with that at all. Obama's gone and it's Biden. How's that going to change anything? And if and you can tell if Romney became president, for example, he already said he would have signed this. So you're stuck in the paradigm of left versus right. Both parties have betrayed you. Both parties are spitting on all the graves in Arlington right now. Every single major candidate in the Republican Party would have voted for this and supports it. The only one that doesn't is Ron Paul. All the rest of them are of the same mindset.
That's a good point, Stewart, and people have got to get that in their head. Part of the problem, a major part of the problem, are the Republicans, for God's sakes. They were involved in this. Lindsey Graham was one of them that drafted. John McCain was one of them that drafted and supported it. We've got to get it out of our heads that the Republicans are going to say this, or some of them think the Democrats. They're the problem. It's the party system that's the problem.
Exactly. I mean, this came out of the modern resurrection of what FDR did in World War II. Came out of a Republican administration. Came out of the Bush administration. They don't care about your citizenship. They don't care about your right to jury trial. To them, they can do what they want. And once the president's elected, he's an imperial dictator. That was the mindset of the neocons in the Bush administration. And Obama's the same way. All Obama has done is taken what Bush gave him and gone beyond it. He's begun to kill us. He's already killed 2 American citizens. You have plenty of Republicans out there that cheer it, they love it, because they're so afraid of Muslims, they're so afraid of, and so angry and wanting to get revenge for 9/11 that they're blind to the destruction of the Constitution. And they're complicit in it. So I think Alan West is probably in that category. I don't think he understands it. What's that?
Or so thirsty for power themselves.
Yeah, I was going to say, a lot of them don't care. They know what they're doing. Like Lindsey Graham was a military JAG officer. He was a military lawyer. He knows exactly what he's doing. Some of them might be, just ignorant and don't know what they're doing. Like Benny Rayburn here in Montana probably just didn't know what the hell he was signing. But either way, it's inexcusable. Either way, it's breaking their oaths. So, it's up to you with your congressman if you want to give them a second chance. Either you can educate them and correct them. As far as I'm concerned, though, once they've blown it, they've blown it. They blew it big time at this one. This is the worst law passed by Congress in the history of this country. It really is. It destroys, like I said from the outset, like Jeff said, it destroys half the Bill of Rights. It also directly violates Article 3. The treason clause of Article 3, Section 2, which guarantees a jury trial for all crimes except impeachment. It wipes away the entire structure of our Constitution. It's terrible. It's as though King George had won the revolution and then declared himself omnipotent dictator. How do we counter the administration's coziness with the UN, especially along the lines of gun control, relinquishing our constitutional rights? Well, if you're an enemy combatant, you have no rights in the Constitution at all. If you have no right to a jury trial, no right to a grand jury indictment, and all the rest of it, you don't have a right to anything else either. This is the problem: is that imagine you're a gun herder in Iraq. That's where you are. You're in the same position as a gun herder in Iraq. If they want to, they can use the Iraqi courts, or if they want to, the U.S. military can get them, pick them up, and take them off to Abu Ghraib or off to Gitmo. And that's what they're claiming to be able to do with us. They're saying that, hey, when we want to use normal criminal procedure, we'll use it. But when we don't want to, we'll use the laws of war. And so don't think the Second Amendment's going to mean anything under that paradigm. So as far as UN treaties, no UN treaty trumps the Constitution. A treaty is only co-equal with congressional law. And like congressional law, must be in accordance with the Constitution.
Stewart?
Yeah.
Some things that we wanted to talk about that we didn't get to talk about, and this is one of the things that came up while you were taking some personal time, is HR 347, and I'm going to put that on the screen so the folks can see it. And
I want to ask a question here. So this is, what about OathKeepers' organization making these arrested for treason? Like I said, I think it's better for you to use your states. That's what the founders did when they were resisting the crown in Parliament. They did it as counties, and they did it as colonies, and they did it as states, essentially. And same thing went with Jefferson and Madison against the Alien Sedition Acts. They went to their state legislatures. And so do it as a state. I'd rather have a sheriff do the arrest. Have a sheriff arrest them, backed up by the legislature and the governor of the state. Or have the state police arrest them. That's much better than having some private organization run around trying to arrest people. That's not going to work out so well.
And Dee had, I've got Dee in my ear, and she's been watching the chat, and there were 4 questions there's some that are repeat questions, but she says that they weren't revisiting. There was 4 dominant questions. Can you give me the first one, Dee? Okay. People are wanting to know where they can get the PowerPoint presentation. 1 second, and I'll show you on the actual website where it's at. And I'm going to move it up so it's a little more prominent. It's going to take me because we're still doing the live stream. I don't want to interfere with the live stream while I'm doing that, but let me go to the website real quick. Let me get it over here off the broadcast. It's not. Close this in. All right. This is the Intolerable Acts homepage. You go to the Intolerable Acts homepage, and I'm going to move it up here to the top. It'll be within the hour. It'll be up here prominently posted at the top. But if you go to the homepage now, you'll see one video, two videos, and underneath the second video you can find, even if we don't have your state up there yet, you'll see the detailed sheriff's resolution and the abbreviated sheriff's resolution, and these are clickable links, downloadable PDFs. And I'll go ahead and tell you what's published up here are the PDF versions, and it's kind of difficult to cut and paste necessarily or work from a PDF. If you'll change the document type from .pdf to .doc, you can download the Word version. But the PowerPoint, you scroll down, you'll see the third video that's on the home page. Directly above that, it says click here for NDAA PowerPoint presentation. The only difference between the PowerPoint presentation that's clickable on the site is that the three videos that you watched embedded in it tonight are not embedded in this version, but on the pages where those videos are, there's a clickable link where you can get those directly. Because we downloaded them and they are parked on the Intolerable Act site. So because some of these videos we grabbed from YouTube, and to ensure that like the webinar, somebody didn't, because that's not ours, that's somebody else's. The webinar is free, so these videos didn't go away. We've captured them, and you can get those. But right now, just go to the homepage, theintolerableacts.org. Look for the Make Mine Freedom video. Directly above it is click here for the Intolerable Acts. And if you give me a second here, I'll copy that link and I'll paste it right here on the screen so you can see it right now. Actually, yes. And next question, D. Yeah, theintolerableacts.org. Okay. Next question was, are we taking this on the road, or are we holding public meetings on this? Stewart, like I said, had been out of the loop. He took some personal time. But Richard and I have already been. I had a death in the family. Yeah, I didn't want to share your business because that's your business. But yeah, Stewart had a death in the family, and took some time away for that. But Richard and I have already been giving these presentations to local government, to grassroots and Tea Party groups, and as it relates to us taking this on the road. It takes funds to do that. Now, the Fire Coalition, the other organization I run, is a 501c3. So if somebody's got the kind of money that can cover the expenses of us taking this on the road, and they want to make a tax-deductible donation to the Fire Coalition and earmark the donation for education on the Intolerable Acts, or Stewart, I don't know how they handle their funding, but that the only thing that's holding us back from doing something like that is funding. Next question.
I can comment on that also. We're going to the OathKeepers is our first stop, our first mission right now for the next 6 months is going to be to put billboards up in front of the major bases in the United States directly on this issue, and then do a tour in conjunction with the billboards. So put a billboard up like a month out, and then saturate all the places where the guys hang out off duty with a flyer saying, hey, the OathKeepers are coming to town, talk about the NDAA. And then, like, say, outside of Camp Pendleton, we'll just, show up after 2 weeks' notice, and we'll hold an off-base event where they can come and learn about this in person and talk to us directly. I'll be bringing, people on my board of directors along with me. And, of course, Richard and Jeff are welcome to come along with us whenever they can. But we're going to go straight to the guys with the guns, with billboards, and with a tour to all the major bases. starting probably with like Fort Benning and Fort Bragg and Camp Pendleton and Lejeune, the most important combat arms bases in the United States, Fort Hood, things like that, and we'll work our way down to every base in the United States eventually, because that's the most critical audience right now. It's the most critical. And of course, along with that, we continue to work with Sheriff Mack and his Sheriff's Project. We just had the Sheriff's Convention down there in Las Vegas. Sheriff Mack put that on. OathKeepers was a major sponsor of it. I spoke there. I talked to a lot of sheriffs from around the country. I talked to them about the NDAA. We presented the draft resolution that Richard and Jeff and I wrote, and we handed all of them a copy of it. And so we're going to keep, whenever I go anywhere in the country to speak, I'll always bring those resolutions with me and tell people, look, this is ground zero. Go to your sheriff. Next to the military, the next most important person in this country is your county sheriff. You have got to go and talk to them and make sure they're squarely on this. And use this as a litmus test. If they will not sign a resolution against the NDAA, like being murdered or kidnapped and taken up to some dang foreign country, then they're not worth it, and you need a new sheriff.
I just saw one in there. Since I've got the homepage up on there, they were asking where they could get the Bill of Rights poster with the voids on it. If you look at the screen right now on the homepage of the intolerableacts.org, just go to the homepage on the left-hand side, right beside Commissioner Littleton and Sheriff Makita, is that a Makita or McKella? You'll see that Bill of Rights poster. Just click on that, and it is a 20 by 30 poster-sized, high-definition quality poster of our Intolerable Acts Bill of Rights poster. And I also saw in there somebody asking about in the chat about would OathKeepers endorse something, and I saw in there that OathKeepers is nonpartisan, and I wanted to echo that the Patriot Coalition and Fire Coalition are nonpartisan as well.
What were they asking to endorse?
It was a presidential candidate rally or something. I just noticed they were asking about an endorsement, and then I saw one of those keepers.
We don't do endorsements in candidate. I might go as an individual. I've been speaking on behalf of Congressman Paul as an individual, but not as OathKeepers. One thing I did want to mention is that there is for those who can make it to California, on Tuesday, April 3rd, is the California Sheriff's Posse Call and Fundraiser. And I'll be speaking there along with Sheriff Mack, and Marine Sergeant Gary Stein is also scheduled to speak. I don't know if the latest events in this case will change that, but let's go ahead and presume he's going to be there anyway. And so if you want to come out and listen to Sheriff Mack and I, and also Gary Stein talk, the Marine who said he would refuse orders under the NDAA, you're more than welcome to join us. And I think John just posted a link to it, but it's a Knott's Berry Farm Hotel in Buena Park, California. And I'll make sure the national site has a link to that too.
Dee, you had another? Uh-huh. Okay. The poster-sized laminated Office Depot for about $35. Next question. Gotcha. And I'm gonna ask a question, and I'm gonna make a comment, and then I'm gonna let Stewart and Richard address that. The question, gentlemen, is what does belligerent mean? And I know that in the Hamdi v. Rumsfeld case, if you look at the Supreme Court's decision, one of the comments they made was that the government's never really told any court what that word means. You want to address that, Stewart or Richard?
Well, we've used the term unlawful belligerent or unlawful combatant interchangeably. And they're getting that language out of various international treaties that now constitute the laws of war, like the Geneva Conventions. And there are different ones, and and a lot of them use different terminologies. So, I wouldn't get too hung up on the terminology. Whether they call you an enemy combatant, which was the term the Bush administration first used, or whether they call you an unlawful combatant or an unlawful belligerent, it's the same thing. They're claiming that they have power to treat you exactly like Abdul, some guy in Iraq. When they point a finger at him and says he's part of the enemy forces, he's either aiding and abetting the enemy or he's taking up arms against us. That's what they call him. They call him all kinds of things. But basically the enemy in wartime. So what the government's telling you is that they can just declare you to be the enemy in wartime. And they use the term unlawful belligerent or unlawful combatant because the argument is that, well, the Geneva Convention only protects lawful combatants. So if you're, for example, not wearing a uniform and not wearing an insignia recognizable at a distance, you're in violation of international law, of the laws of war. And you're not protected, which means they could just try you for that violation and hang you like a spy. That's the argument. They want to be free, not just free of the Constitution, but also free of even the international laws of war themselves, as far as the Geneva Conventions for treatment of POWs.
Right. Stewart,
Execute you.
I'm putting something on the screen that's out of the 2010 Law of War Desk Book that speaks directly to that issue. And one of the things they did was, and there's so many different variations of laws of war or whatever, and when you're looking at the NDAA and they say the law of war, like Stewart was saying, there's the Hague Convention, there's several Geneva Conventions, there's additional protocols, but this is directly out of the U.S. government's official 2010 Law of War Desk Book that says neither as far as the term unlawful combatants, neither the Geneva Conventions nor AP1, Additional Protocols 1, recognize or define a third category of quote-unquote unlawful combatants. Domestic courts, however, such as the U.S. Supreme Court, have defined the term. The U.S. Congress previously defined unlawful enemy combatant for purposes of trial by military commission in the Military Commissions Act of 2006. In 2009, the Military Commissions Act was amended and instead defined the terms as privileged belligerent. It means an individual that belongs to one of the 8 categories that are recognized under the Geneva Convention. So what I pointed out in an NDA presentation last night, that this is kind of a lot like what President Clinton said when he was in the Lewinsky case. It depends on what is. It depends on what enemy combatant is.
Yeah, look right there. If you folks look at you can see the notes right there. It says to qualify for POW status under Geneva Convention 3 Article 4, militias and organizations, organized resistance movements belonging to a party to conflict must, 1, be commanded by a person responsible, well, why minimize, responsible for the subordinates. Jeff, can you pull it back up?
You want the highlight on the notes? Okay, let me get all the notes up there.
I can read right there. No, scroll back up. Scroll back up. Right there. It says it must be commanded by a person responsible for his subordinates, or 2, have distinctive insignia visible at a distance, or 3, carry arms openly, and 4, conduct operations in accordance with the laws of war. I want to ask the listeners, how many of you have a concealed carry permit? Well, if you're not carrying your arms openly, once the president points his finger at you and says that you are a belligerent in the war on terror, the fact that you don't carry openly because you carry concealed, they could say that's a violation of the laws of war. And if you don't have a distinctive insignia visible at a distance on you, like an armband. I know it sounds absurd, but that's the problem with this war paradigm being applied to us, the people of the United States. They could apply under the laws of war. When I walk around every day, I don't have an armband on, and I carry my pistol concealed. And so I'm in violation right then of those 2 of those elements that would make me a privileged belligerent. So I could be, I would have protection by the POW status. So this is, and I could be tried as an unlawful belligerent by some kangaroo court set up by Obama, and then either incarcerated in Fort Leavenworth or Gitmo, or I could just be killed. and Obama could just have a Predator drone fly over my house and blow me up. I know it sounds absurd, but that's the legal claim they're making, is that there's no difference between here and Iraq, and that these rules apply to you and me once the president says they do. And it's say so alone. He does not have to go to a judge and prove that. He just designates you. Once you're designated, it might be like Al Walkie, might just kill you. And the only real limit on that now, according to the courts and according to the Congress and according to the president himself, the only real limit is the president's discretion. And so it's just whatever he thinks he can get away with politically. That's kind of how it goes right now in this country. And so I hope you guys can understand that. Your Bill of Rights protections only apply if the president wants them to. Once he decides they don't, according to him.
All right, and for that, I'm gonna make these available, but just so you can see, this is we don't make this stuff up. I wish we were making this stuff up, but this is the official government's Law of War desk book, and they put a new one out every few years. There's another document I want to put up that has some citations from the Hamdi decision that are directly related to what we've been talking about tonight. While Stewart was away because of the death in his family, and I may be getting a little bit ahead on this one because there's several bills out there that allege to do something about the problems with the NDAA. And one of them is Congressman Landry's bill, H.R. 3676, and it does absolutely nothing. I'm not going to go over that tonight. We're going to do a separate one of these just to address the legislation that's going through Congress that gives the illusion that they're actually intending on doing something about it. But because of something that occurred while Stewart was gone, we got a call from Congressman Landry's office about a hearing that was going to be held on February 29th in the Senate Judiciary in support of a bill introduced by Congressman Garamendi. That's H.R. 3702. And the Senate hearing was for S 2003, and you can go to Judiciary to the Senate to Senate.gov. It's either judiciary.senate.gov or senate.gov/judiciary, and go to hearings and look for the hearing on the Due Process Guarantee Act of 2011. And what the gentleman that called us from Congressman Landry's office wanted us to put the word out that this hearing was going on, and he was excited because both Congressman Landry and Congressman Garamendi were going to go over to the Senate to testify at the Due Process Guarantee Act of 2011 hearing. And what this hearing, and they were on the first panel, and you can go watch the video. I just want to share a little bit about this, and then I want to get the attorney's response. But this was the opening statement from Senator Leahy. He said, "I opposed and will continue to oppose indefinite detention. I fought against the Bush administration policies that led to the current situation, with indefinite detention being the de facto policy. I opposed President Obama's executive order in March 2011 that contemplated indefinite detention. I opposed the provisions in the NDAA as well. A regime of indefinite detention degrades the credibility of this great nation around the globe, particularly when we criticize other governments for engaging in such conduct. Indefinite detention contradicts the most basic principles of law that I've pledged to uphold since my years as a prosecutor and in our senatorial oath to defend the Constitution. That is why I am fundamentally opposed to indefinite detention without charge or trial." This was the chairman of the Senate Judiciary's opening statements at that hearing on February 29th. Now, what this bill does, and I'm not going to go down the weeds on it, but it makes changes to 18 U.S.C. 4001. That's a limitation on detention. And if you look at the title, Due Process Guarantee Act, it sounds really good. Well, the title Patriot Act sounded really good too, didn't it? This is what it would change. It says it would change 18 U.S.C. Section 4001 to read as follows. An authorization to use military force, a declaration of war, or any similar authority shall not authorize the detention without charge or trial of a citizen or lawful permanent resident of the United States apprehended in the United States, and this is what kills me, unless a drone does, unless an act of Congress expressly authorizes such detention. Well, I got a problem with that right there, that Congress thinks that they have a constitutional authority to authorize such a detention. When you go down, and you can get this document as well, and I made reference to the Hamdi v. Rumsfeld case, and both Richard and Stewart can speak to that at length. But this is directly out of the Supreme Court prevailing opinion, writing for the majority. Justice O'Connor said, the government, and we talked about enemy combatants, the government has never provided any court with the full criteria that is used in classifying, let me make this a little bigger so you can see it easier, in classifying individuals as such. And there were two main arguments that the government was making to the Supreme Court. And the first was that the president didn't need congressional authority because he had plenary authority under Article 2 as Commander-in-Chief. And that was one of the arguments that was made on the floor in some of the floor debates. But this is what they said. They argued that first, says the government again presses two alternative positions. First, it argues that Section 4001A, in light of its legislative history and its location in Title 18, applies only to the control of civilian prisons and related detentions. And if still, if you keep that thought in your mind about the difference between civilian prisons and related detentions as opposed to military prisons, I want you to comment on that. But they said, we conclude that the government's second assertion is correct. We conclude that the AUMF is explicit congressional authorization for the detention of individuals in the narrow category we described, assuming, without deciding, that such authorization is required. So the court didn't even address whether or not the president needed congressional authority based on his plenary authority under Article 2 as Commander-in-Chief, but they agreed with him on the second one, and I'll continue, that the AUMF satisfies Section 4001A's requirement that a detention be pursuant to an act of Congress. Let me skip on.
Let me comment on that. This is one. Whenever you hear somebody say, "Oh, this doesn't apply to U.S. citizens," it does, because the 2001 AUMF, which the NDAA of 2012 purports to affirm, has already been interpreted by the U.S. Supreme Court as authorizing military detention of U.S. citizens, like Jeff just said. And the argument, when they were arguing over the Hamdi case, the Bush administration argued that they don't need congressional approval. The president has an independent power as Commander-in-Chief to do this and to detain U.S. citizens. And further, they argued that Congress cannot prohibit it. Well, the Supreme Court has just said, the other side, the argument by the ACLU and everybody else on the other side was only a separations of powers argument, that Congress hasn't authorized this. None of them went to the heart of the beast and said, no one can do this. Congress can't do it. The president can't do it. No one in the federal government can do this, because Article 3 of the Treason Clause mandates a jury trial for anybody accused of making war against his own country or aiding the enemy. Those are the elements of the crime of treason for an American citizen. And those are exactly the same things that the president claimed the authority to use military jurisdiction against an American for. That is what Scalia pointed out in his dissent. I encourage you all to go look up Scalia dissent Hamdi, or Jeff can post it on the site too.
Yeah, well, Stuart, if they go to our blog, and you have to scroll down because there's a few articles down, there's a considerable portion of Scalia's dissenting opinion that was in a December 15th or December 16th article that I wrote about the Congress issuing a death certificate for the Bill of Rights on Bill of Rights Day, because that's when the Senate did. Yeah. All right.
Or just go look up Scalia's dissent Hamdi and see his dissent. And he points
Yeah, Stewart, hold that thought, because there's one more thing I want to show them here, and then I'll go grab that. To put this in context, y'all remember the Senate debate when the Senate was debating 1867, and they had this compromise amendment that Senator Feinstein introduced, and that was the requirement doesn't apply amendment that all these members of Congress are leaning on. That no, y'all are talking about something. It just doesn't make sense. Y'all don't know what you're talking about. This is the same kind of language, and you look here what Justice O'Connor said. Unless, where's it at? Did I scroll up too far? It was expressly authorized. I'm sorry. Here it is. Assuming they couldn't do it unless it was expressly or explicitly, and that may have been in this quote up here. But you go back to, this is the reason I was stopping you, Stewart. This is legislation that has a lot of support in the House. There's over 62, last I checked, co-sponsors on the Garamendi version, which is identical to the Senate version of the Due Process Guarantee Act of 2011, and the Senate version was introduced by Senator Feinstein. Here it is. Back at what the Due Process Guarantee Act says it would do. It says an authorization to use military force, an AUMF. You can't do it unless an act of Congress expressly authorizes such detention. And then you go back and you look at what Justice O'Connor said, that they've already explicitly done so with the 2001 AUMF. So that Due Process Guarantee Act is no different than the amendment that they added to Senate 1867 when it was 1031, 1032, to try and dispel the restless natives and to fool the people that weren't doing their homework.
It's empty rhetoric, and even aside from the fact that the court's already interpreted the 2001 AUMF as authorizing this, the NDAA of 2012 just very clearly authorized it. It says any person. That means what it says. Lawyers write that stuff for a reason. It doesn't say any person except U.S. citizens or any person who's not a U.S. citizen. It says any person that the president determines meets these elements may be they have the law of war applied to them for detention, trial, or rendition, or even military force. Remember, he can just kill you, according to his logic. He's already done it. So yeah, I mean, there's a bunch of there are attempts, and some of them might be sincere, to fix this, but everyone I've seen is flawed. And so what we're going to have to do, I think Richard and I and Jeff should talk about this, is we need to draft a model bill for Congress that would fix this completely. Like I said before, it can't just repeal ND 2012 or these provisions, 1021, 1022. It has to also withdraw any consent by Congress, and it should also declare a prohibition that Congress declares that the U.S. military may not use military force, detention, or trial against U.S. citizens, period. The remedy must be trial for treason. That's the full way to slam the door all the way shut and then force Obama to argue that he has some kind of independent power that Congress cannot, or Romney by then probably, that Congress cannot impede. And I want to answer one question earlier. This guy Dave keeps harping on Arpaio, and he says NDAA and Sheriff Arpaio's case are connected. When with the sheriff, an NDA will fall. Why don't you discuss this? Dave, you have not been paying attention to anything we've been talking about. This didn't come out of Obama. This came out of Bush. And it's come out of a congressional statute. If Obama disappeared tomorrow, it became, the guy from Kenya and Biden took over, we'd be in the same boat. Or even if Romney was president, we'd be in the same boat. I don't know what you've been listening to. If you're someplace else, came back. But you've been missing the whole thing. It doesn't make a difference what happens to Obama. This power is there by court decision. This power is there by statute, passed by Congress. And every swinging Richard out there on the Republican side, except for Ron Paul, loves this. So I think you need to open your eyes a little bit wider than the birther issue when it comes to Obama.
All right, before
I think Sheriff Arpaio is doing a good thing when it comes to that issue, but that will not fix this. It will not. I don't know why you think it will, but it just won't.
all right, if you go to the Patriot Coalition blog and you scroll down, it's 2 or 3, 4 articles down, you'll see this one: death certificate issued for Bill of Rights on 220th anniversary by 86 U.S. senators. In that document, there's a considerable amount of the Scalia dissenting decision. And when you get to, if you go to that article, there's a direct link to the Hamdi v. Rumsfeld case at Cornell Law Library. And if you click, you see where my mouse is now. This is the entirety of Justice Scalia's dissenting opinion. And I didn't post the entire part, the entire dissenting opinion, but there's a considerable amount of it here. So you can either go on to Cornell Law Library, or you can just go directly to the Patriot Coalition blog, scroll down, find the death certificate issued article on a Bill of Rights, and then scroll down and look for Justice Scalia's dissenting opinion. And which particular part were you referring to, Stewart? Because it's probably in here, because he said a lot.
But he points out 2 things. He goes, first of all, there could be no detention of a U.S. citizen outside of a grand jury indictment unless and until there's been a suspension of habeas corpus. And that has not been done. And when I was a student at Yale Law School, I had dinner with 3 federal judges who had been on the Padilla case, because my professor was one of them, was one of the judges on the same circuit. And one of them admitted that, he said, look, I said, hey, you guys suspend habeas corpus. Why don't you do that? And he said, that's not politically feasible because of what Lincoln did during the Civil War. It's not politically feasible, so we can't use habeas suspension, and so we got to do something different. So he was basically admitting that he was doing what he wanted, not what the Constitution demands. And so they created this whole doctrine to get around the constitutional requirements. You can only detain under habeas suspension. Without that, you cannot. That's what Scalia pointed out. Number 2, he said, when it comes to a trial remedy, he said the treason clause shows us the traditional remedy, he calls it, what we've done traditionally with people accused of Americans accused of making war against the United States. I would go further than Scalia and say it's not just a tradition, it's the friggin' law. It's right there in Article 3 of the Treason Clause. The founders put that there for a very good reason. They knew the accusation of treason was the worst thing you can accuse anybody of. And they experienced it themselves. And they had seen the history, like I said, of the Star Chamber in England, of kangaroo court trials on accusations of treason, where people were tortured, forced to confess against themselves, and then executed after being found guilty by a panel of judges appointed by the king. That's what they did not want to see happen here. That is why the Treason Clause mandates a jury trial and says it has to be upon 2 witnesses to the overt act or confession in open court, not confession behind closed doors when they've got a cattle prod on their nuts. Okay? Let's do confession in open court. So Scalia pointed this out in his dissent. He's like, what are you guys talking about? And he told the majority in the court, he said, what you're doing is playing Mr. Fix-It. You're designing some new system that you a hand in, is what he accused the court of doing. And he told the court, he said, look, what you're really doing here is protecting your own turf. The majority in the court just wants to be involved in designing the new system. They're not adhering to the Constitution, and Scalia was right.
Those are the exact words he used, Mr. Fix-It. And I thought that was one it may be in a subsequent article. We're going we haven't made the update to this document here. While, like I said, Stewart was dealing with a death in the family, and to respect that, we left him alone. And so Richard and I and some other attorneys that work with the Patriot Coalition did the background on this, but we felt it was important enough that we didn't just want to put it out under the Patriot Coalition. We wanted to do it under the Intolerable Acts, and I'm back on the Due Process Guarantee Act, because this is something that's still in the pipeline that needs to be stopped. because what's happened is over the course of time, Congress is recodifying more and more in the law this concept that they can do anything they want, and it's outrageous that this is even out there, and they know they can pretend all day long that no, that's not what it does, or they didn't know that's what that language meant, or they didn't know what it says in the Hamdi decision, what the Supreme Court's already ruled. Well, it's out there. But what I was going to say is that we haven't updated this document yet, and the reason it's got one of the Mr. Helms' name on it in the board of directors is because Stewart was respecting his privacy. But we're going to be updating this and put Stewart's name on there as well, because since he's been back in the loop, he's put his personal stamp on it. So it's got his stamp, and it'll have his stamp and the OathKeepers board's stamp on it. There are about 4 or 5 different bills. There's another one we're not going to get into tonight because we're coming up on 2.5 hours. But as Stewart alluded to, as far as OathKeepers endorsing or not endorsing, Patriot Coalition doesn't either. I may personally do something like that, but not for the coalition. So what I'm going to say next is not an endorsement whatsoever. But if there is a bill in Congress right now that will do anything whatsoever, again, like what Stewart said a while ago, just getting rid of this executive order, the NDPR, or the birther issue. If you deal with Obama as the birther issue is a valid issue and you took him out of office, it goes much deeper than that, and it goes much further back than that. And even if this bill here that's introduced by Congressman Ron Paul, and co-sponsored by my congressman who didn't vote for the NDAA, Congressman Walter Jones is from the 3rd District of North Carolina, is one of only, last time I checked, 4 co-sponsors of a bill that will actually do something. The Garamendi bill has like 62 co-sponsors. The Landry bill, which does nothing. Now, I say the Garamendi bill, that's the Due Process Guarantee Act that mirrors the Senate bill introduced by Senator Feinstein that does nothing but say we won't do anything that we haven't already done. There's only one bill, and that's this one, that will do anything. And even if this one passes, there's a lot more that needs to be done, and this is H.R. 3785 in its entirety. It's 8 lines long, and it simply says, Section 1, repeal of Section 1021 of the 2012 NDAA. Section 10, starting on line 6, Section 1021 of the National Defense Authorization Act for fiscal 2012, Public Law 112-81 is hereby repealed. Is hereby repealed. Simple language that anybody can understand. There is no way to misinterpret, misapply. What does is mean? What does hereby mean? What does repealed mean? It says what it says. It means what it says. And it's a good start. You want to comment on any of that, Stewart or Richard?
On that, just want to make one comment on that. But like I said earlier, even if you repealed and went back in time and got rid of 1021, if you repealed, 1021 and 1022 of the NDAA, you're still back in the territory where you already had a Bush detaining people, you already had Obama killing American citizens pursuant to the 2001 AUMF, and so far backed up by the federal courts. So we're still, it would make it's not as bad, but still, they're still doing it.
Stepping away for 3 minutes.
That's why we have to close that door all the way by saying, and the authorization of use of military force 2001 does not include the authorization of military force detention, trial, or rendition against U.S. citizens is what they would have to do to close that door. And even better, to say, and further, the U.S. military is prohibited from doing so. So not only do we not authorize this, you cannot do it. We're saying no. And then the president would have to prove that he can disregard Congress. So this is what would be like the dream bill would be all the way that far. This is a good first step, but there's 2 more steps beyond that should be done to slam this door all the way. and then let it. Then will be a real battle between Congress doing the right thing. And all these bills so far that I've seen Congress throw out there basically say you can't do it unless we say so, which is saying, hey, someday we might want to say so, you know, and they already have said so in the 2001 UMF. So anyway, I won't beat a dead horse, but none of these bills are going to fix anything. And even Ron Paul's bill does not go far enough. It's a good start, but we kind of slam the door all the way shut. So that's why I'm hoping Richard and I can draft a bill that does everything. Richard, you got something to say about that?
I'm looking forward to drafting that bill.
Let's do it, man. I can't wait. It'll be fun. I mean, we'll make it the. I want to pull any stops out. I'm going to pull all the stops out. I mean, make it
that
the
will probably make it
perfect bill.
Combatants again.
Oh yeah. Well, we're already on this anyway. I wanted to answer JT's question earlier. JT had asked, "What do I tell Marines when I hand push cards to who support us but are concerned about retaliation?" What I would tell them is what counts is whether or not they keep their oath. It's not about whether they join OathKeepers or not. And there is a serious cause for their concern. Look at what's happening right now to Gary Stein, the Marine Sergeant from Pendleton. So if some of them want to, I think that's fine. A good analogy is an iceberg. It's necessary to have some active duty joint OathKeepers who are that visible tip of the iceberg so that the powers that be know we're not playing, that we're serious. But it's also good to have the rest of them be under the surface, that you don't know who they are, we don't know where they are, we can't quantify them, and that scares the bejeebers out of the bad guys because they can't game it. They can't figure out how many they have to worry about. I want them to worry about how big that iceberg really is. I don't want them to know. So I think it's a good idea. Tell them, hey, if you want to be like Gary Stein, be a stand-up guy, and be that nail that sticks up and might get hammered, go ahead. We need people like that. But if they choose to stay under the surface and not join officially, then we're not going to criticize that because that is their choice and it's a valid concern and it's part of our strategy, but not all of them should step up. Okay? I hope that answers JT's question. What other questions do we have here? How do we repeal the ability of the executive to sign executive orders? Well, on that one, like I said yesterday in the discussion about the executive order that Obama just issued on emergency preparedness and all that, and production and resources, all of those executive orders on emergency powers go back to that 1950s statute. And I think there are a couple other statutes passed by Congress that we still haven't looked at yet. So one of the ways to get rid of those EOs is to take away the statutory authorization, the statutory basis for them. So Congress should repeal, I would say Congress should repeal that one act from 1950. It was called the 1950, hold on, I'll get the title for you. Defense Production Act 1950. That needs to be repealed or substantially amended to remove the two worst parts were the ones that authorize the president to declare certain items to be hoarding. If you hold a certain item above a certain amount, you could designate those items be critical items that you're not allowed to hoard. That's a direct violation of your property rights. And the second one that was really bad was a delegation of authority for him to allocate resources. And that's the heart of all of these EOs that run around talking about confiscating farms and farmland, farm equipment and food and vehicles. It all comes from that language in that statute from 1950s that talks about him being able to allocate resources. So if you want to gut these EOs, take away that statutory authorization from Congress. It's been sitting there forever. So that's one more we should probably draft up, Richard. There's another bill like that. What do you think?
Absolutely agree.
So we'll be awful busy. And I'm going to put out a blast tomorrow to all the whole OathKeeper list asking for attorneys that want to help us in anything we might need. I want to put together a cadre in every state of good attorneys And then I think Jeff and Richard could do the same thing to their network too. And I'm also going to ask for any former JAG attorneys who would like to help with the Stein case or other cases like that. I expect there's going to be more like that. I think this is not the only one you're going to see. You're going to see more people in the military being prosecuted just for speaking out and saying that they will not follow unlawful orders. Okay, what are the questions we have here? Why do you think, for the most part, only the CBC voted against the NDAA? What's the CBC? Mark, what is CBC?
I hear a pause, and it was more than 3 minutes. But I've got a comment about the birther issue myself that I haven't said. I'm back in the broadcast D. I got our Southwest coordinator and Kansas director in my left ear. I saw 3 years ago, personally, stuff that was eyes only regarding the legitimacy of the president, or illegitimacy, if you will. But we have to be realist about this. I'm a strict constitutionalist, and we argue all the time that we, the people, are the ultimate arbiters of whether something is constitutional or not, that Congress is not, that the Supreme Court is not, that the president himself is not, that we, the people, are, as the sovereigns, are the ultimate deciders, to steal from President Bush. Well, in 2008, in the general election, the people looked at then Senator Barack Obama and said, he's good. The people spoke in 2008. The horses left the barn. If you want to focus on the birther issue, in my opinion, you should focus your pressure on not proving that this guy wasn't legitimate, but focus on getting legislation passed in Congress and in your state election commissions, your state legislatures, state government, to tighten up the requirements for certifying candidates to even run for office, so that it doesn't happen again. So we don't have all this. There's been so much time and money in court cases. It's a honeypot. That horse has left the barn. Like I said, I saw enough evidence in myself personally that was eyes only in 2009. I'm convinced he's not eligible to be president. But he is president because the people spoke. We need to focus our efforts, in my opinion, on tightening up the election laws and the vetting process for validating and certifying candidates to be eligible for the offices that they're going to run for, so we won't have this problem in the future. If there is a United States government in the future that is bound by the supreme law of the land, the United States Constitution. And as Forrest Gump would say, and that's all I had to say about that. You still there, Stewart? Or Richard, you still there?
Yeah, I'm here. Mark asked a question about the Congressional Black Caucus. I guess he means as a group that they were against the NDAA. It's kind of sad, but it tends to be, you get more people against the NDAA on the political left because they remember the Bush years when Bush was doing it, opposed it, and a lot of them still oppose it, to their credit. Unfortunately, very few Republicans are against it because during the Bush years, Bush was doing it, and they were all for it. And I think it might just be an accident of history that you had, Republican president first doing it, and therefore you had a lot of brainwashed and Kool-Aid drinking Republicans who think it's great, And so I don't know how else to explain it, but it came out of a Republican administration. But now it's been adopted by a Democratic administration and a lot of Democrats too. So I think the difference between the Democrats and Republicans is pretty small. It's only a handful in the House voted against it. Only a handful, even worse, in the Senate voted against it. So I wouldn't pay too much attention to that. But I do notice there tends to be more on the political left who are upset about it in the mainstream parties than on the political right. But that is changing a lot. lot of people now on the political right are realizing how bad this is, and so it cuts across all party lines, which is the good news. There is a groundswell of resistance to this among Democrats and among Republicans. It's the one thing we can agree on, at least this, that we should not be subject to being assassinated or black-bagged and taken off to friggin' Egypt to be tortured. We can agree on that.
Right. I want to show him something that shares, since the gentleman brought up caucuses. If you look at the screen, I'm back on the Intolerable Acts homepage, and on the left-hand side, left-hand column, you see the Intolerable Acts logo. And we'll scroll down. We put out an open letter signed by Stewart and myself, an open letter to Congress, and you'll see that right underneath the Intolerable Acts logo on the left side of the homepage of theintolerableacts.org. That is an open letter to the Congressional Constitution Caucus. Now, one of the things that and this has been several years ago, 2007, I was really frustrated that these people take all these oaths, and this is before there was an OathKeepers organization, that there ought to be there's a whole bunch of caucuses out there, and there ought to be one to address this. And we were working with then Congressman Virgil Goode from Virginia, and Congressman Paul and Congressman Walter Jones, in support of Congressman Goode's HRC 40 that was to get us out of NAFTA, the North American Union, or stop the North American Union and Security and Prosperity Partnership push, and the NAU. And it was around that time that it was brought to my attention that if you held up the voting records of members of Congress to the Constitution, that Congressman Paul had the best voting record of any member of Congress. And then I found out, talking to Congressman Goode, that there actually was a Congressional Constitution Caucus. When you look at the NDAA, and we put out this open letter, and this was sent to every member of the Congressional Constitution Caucus on behalf of the Intolerable Acts Action Center, OathKeepers and Patriot Coalition, on February 22nd. And you can download this yourself and find out, because there's links in here to which members of the Congressional Constitution Caucus voted for it. And I just want to read a quick quote here from it, the intro to this letter from OathKeepers and the Patriot Coalition directly to the Congressional Constitution Caucus. Representative Garrett, who chairs and is the founder and chairman of the Congressional Constitution Caucus, tried to get two rules of the House changed at the beginning of the current session when the Republicans took back over in January of last year. And you can only change the rules of the House at the beginning of each Congress. And the Congressional Constitution Caucus tried to get two resolutions passed. One of them was to require a constitutional authorization statement be attached to every bill that was introduced. And if you go to house.gov to Congressman Garrett's site, you'll see him on his site about these resolutions or House rule changes, that members of Congress, instead of applying you hear them all the time talking about the general welfare clause and necessary and proper clause. Well, those are like with the opening and the ending paragraphs of the enumerated powers, the things that the federal government was authorized by the states to do. And that was the biggest complaint that Congressman Garrett had, was that they're always using not the actual enumerated powers to justify what they're doing, but using the introduction, the explanation of what the enumerated powers were, the general welfare clause and necessary and proper clause. And when I saw the NDAA vote, how strong it was in the House, I went to check, and we had one of our researchers, in fact, that's the person in my ear, our Kansas coordinator, or Kansas director and South Central coordinator, and we already had compiled a list of the members and contacts for them all for the Congressional Constitution Caucus. And Dee was kind enough to bounce that list across the NDAA voting record. and some startling results. And despite your no vote, because Congressman Garrett did vote against it. Oh, I'm sorry. Before I get ahead, those two the constitutional authorization statement was adopted by the House. So when you go to Thomas and you look at bills and you see a authorization statement, that's a result of Congressman Garrett's efforts. The other thing he tried to get them to do, the other resolution or House rule change, was to require members. You can't require members of Congress, but they could require staffers to take Constitution training comparable to the ethics training. So we talked to the ethics committee to find out what members of Congress as staffers were required to take as related to ethics if they were wanted to mirror that to a annual Constitution training for staffers. And we found out that if you are senior staff, let's say like a chief of staff or general counsel, you are required to take 2 hours of annual training on ethics. And if you were a lower staff, regular staff, 1 hour a year of ethics training. So the resolution or rule change proposal that Congressman Garrett had introduced regarding Constitution training for congressional staff was only going to require senior staff to take 2 hours of Constitution training a year and junior staff 1 hour a year, and it failed. And a lot of it, because these bills are so convoluted, the NDAA, once it made it through the conference committee, the final version of H.R. 1540 conference report is 1,844 pages long. Well, there's thousands of bills introduced. No congressman trying to do due diligence to his oath of office can possibly read, digest, dissect all the legislation put before him. He's got to rely on staff. And if the staff aren't even required to take 1 hour for junior staff and 2 hours for senior staff, if that's too much to ask to be a change to the House rule, something's wrong there. So the opening paragraph to our open letter to Congressman Garrett says, despite your no vote, a supermajority, 72%. And like I said, I showed you where it's at. It's on the Intolerable Acts homepage on the left side, directly under the Intolerable Acts logo. You can download this PDF and you can click on all this, because we don't make stuff up. We source it directly to congressional and official government documents, and these are the voting records for this. 72% of the Congressional Constitution Caucus voted to nullify the Bill of Rights. 72% of the caucus, whose very name is Constitution Caucus. It's outrageous. I encourage you to go to the Intolerable Acts, download this PDF, and click on these links here to find out if your congressman or your senator, if you didn't already know, if they voted for or against the NDAA. These are the ones. This PDF where it says 72%. That'll tell you if you're a member of Congress, your congressman is a member of the Congressional Constitution Caucus. You want to click on this 72% and see if they voted for the NDAA. And download this letter if they did, or even if they didn't. And then here's some more of the stuff from what Stewart was talking about, the Mr. Fix-It. I knew it was in something that we had put out. It's in the open letter to Congress, what he was referring to from the Hamdi decision with the Mr. Fix-It comment. It says there's a certain harmony of approach in the pluralities making up for Congress's failure to invoke the suspension clause, that's Article 1, Section 9, to suspend habeas corpus, which they would have to do. And there's only 2 times that they could possibly do that, and that would be invasion or rebellion, and then only if the public safety required it. And that's not been done. And nobody's argued that they've done that. So people have said they've suspended habeas corpus. They haven't. They're out. We're back to the what is. They're not wanting to operate under the Constitution, and we showed you in the official government 2010 Law of War Death book where they said even the Geneva Conventions don't recognize these unlawful combatants. this third term that was created by Congress in 2006 and then updated in 2009.
Yeah, the argument is that the Constitution doesn't apply, that what applies is the international laws of war. And the argument basically is that they don't have to suspend habeas corpus because this is not a habeas corpus issue. In fact, they'll even tell you, oh, you still have habeas review. A lot of these responses from the senators and congressmen say things like, oh, habeas corpus is still in effect because you're going to get some review by some military judge once you've been designated by the president as unlawful belligerent. You'll eventually get a review by some military judge. And they say that satisfies the requirements of habeas corpus. So it's a very Alice in Wonderland thing. They're saying that the normal due process you get in the criminal system just doesn't apply, that the military system will now apply under international laws of war, and that satisfies your due process. That's what they're saying. So due process is still in effect. That's what they try to tell you. Don't worry, you still have due process. But what they're not telling you, that due process, the process they consider the duty to, is some dang military judge in Guantanamo.
Right. And I'd said earlier there was only one bill that did anything, and I'm bringing this up because of what Stewart just brought up, and this is directly from. Let me go to the back top so y'all can see it. This is the bill that was introduced by Congressman Landry on Bill of Rights Day in response to the Senate passing the NDAA. And there's several good folks that are co-sponsors of this from Bill of Rights Day. And what it was going to do was amend the NDAA to address due process rights of U.S. citizens. And this is a bill that's out there that a lot of people are promoting, and there's a lot of people that voted for the NDAA that are now signatories, co-sponsors of this bill. And it's got two categories, protections for citizens and another one for lawful resident aliens. And when we've got a position paper on this, I haven't published it on the Intolerable Acts site yet. I'm not sure. We've been doing so many things. I'm not sure if Stewart has and OathKeepers legal people have looked at it yet. But I'm sure they're going to agree with the paper because it basically says what Stewart just said, and that is all the rights of due process afforded to citizens in an Article III court. And this is the Landry bill. There's a difference between due process in an Article III court than getting due process like you would get in an Article III court. And if you want to speak to that again now that this is on the screen, Stewart.
Well, if you look at the Hamdi decision, what it says there is that he says, a U.S. citizen so designated has a right to challenge, a right to a meaningful challenge of that designation before a neutral decision maker, and that could be an Article III court, or the court said, or it could be satisfied by a military tribunal. But even if under this statute, if it were passed, even if it get reviewed by some federal judge, it's going to be the same kind of crappy review that Padilla got in the Second Circuit, or it's going to be the same kind of crappy review that he got down in the Fourth Circuit, or the Hamdi got. It's going to be some evidence standard. The courts so far have said that it's not their place to second guess the president. They're going to be very deferential to his determinations. And so it's going to be some minimal due process by some federal judge, and that's not constitutional. Even if the federal judge held a trial, it's not constitutional. Even a jury trial, Article 3, Section 2 says so. And so there's the Sixth Amendment, and so there's the Treason Clause, Article 3, Section 3. It's the only thing that satisfies the Constitution is a jury trial. The ancient right of jury trial our forefathers bled to keep. That's what we are entitled to. That's our birthright. Anything else is garbage. So Congress is throwing out garbage at us, saying, "Oh, sure, you'll get the due process due you and the habeas review due you in an Article III court under the Padilla decision or under the Hamdi decision." That's all that's saying.
I'm checking it right now.
I can answer one point. Someone said anything can be made legal to appear legal. All you need is a judge to wrestle the words in submission. Juries are eliminated under these laws, and that's correct. And that's the problem. That's the problem with relying on constitutions, is that if you rely on a constitution and don't pay attention to what's going on and leave it to the judges, leave it to the so-called experts, they will betray you, and they will make anything legal. What they've done here is they basically made everything that Hitler did in Nazi Germany, they've made it legal. They've made it legal for the president to simply point his finger at you and kill you, order you killed. It's like some friggin', poobah from a third world dictatorship or some emperor in ancient Greece or Rome. He could just point his finger and have you killed. And they're saying that's legal under his powers as commander-in-chief under Article 2. And the sad thing is that so far, I haven't seen a federal court yet that has directly countered that. They have bought into this war paradigm as applied to Americans. When you look at the Constitution of the Weimar Republic before the Nazis took power, it was flawed. It had what was called Article 58, which allowed for the suspension of certain due process rights and civil liberties. And that was evoked after the Reichstag fire. Well, our Constitution does not contain that. The closest thing to it is habeas suspension. That's really it. That would only allow for detention, and only in the limited circumstances of an invasion or an insurrection. But even that wouldn't allow them to kill you. They could just detain you temporarily. But what they've done is what's not there, they have tried to create through the international laws of war. They're arguing that when the founders rebelled against the king and parliament and fought that revolution to preserve jury trial and to keep admiralty courts from being used against them, that they turned right around and created a government and a presidency with even more power than the king had. That's their argument. And somehow the founding fathers missed that the anti-federalists like Patrick Henry and George Mason, who opposed the Constitution because they thought it was too powerful, it gave too much power to the federal government. But the argument is basically that Patrick Henry didn't see this. But there's this power that's always been there in the presidency that once he's elected, like an elected dictator, and he can just kill you or have you, black bag and throw in some dark hole. That's their argument. It's an absurd argument that they have convinced enough judges and enough people in the political class that agree with this that they are now, de facto imposing this upon us. And so we are, like I said before, we're pretty much in the same posture as the founding generation was in 1774. We have one narrow window to correct this politically by sweeping out all the oath breakers who voted for this and putting good people in, or strong-arming them enough to pass a new statute to repeal this and split the door shut and prohibit it. If we don't do that, though, we're in a lot of trouble. And even if we did that, the problem with that is that because the stupid courts have agreed with this power, they're now in this twilight zone where the battle is in the Congress. And someday, even if we repealed these bills and passed bills to prohibit this being done, all it would take would be a new Congress after the next terrorist attack step in and say they can do it again. And so we're in a pretty bad place constitutionally in this country.
Yeah, Stewart?
Have a solution other than the state standing up and rebelling, and it might come to the point where we have to fight another revolution. So
it is now 12:08. We've been going at this for 3 hours and 8 minutes, and we need to start wrapping it up. We got to look out for our staff as well. And I say staff, we're all volunteers. Nobody's getting paid, and we're not wanting to work them to death. But we're going to be doing more of this on live stream, and we're going to be upgrading our account to a paid account there so we can broadcast in HD sometime in the next month, I hope. And it's all a matter of funding. If anybody's listening and wants to help with that, they can make a tax-deductible donation to the Fire Coalition and earmark it for, you can go to livestream.com. They've come down on their rates, but if somebody wants to make a donation to the Fire Coalition and earmark the donation for live stream update, that's exactly what it'll be spent on. Do you have any, I can't say we're going to do these every week because we've got a lot of other stuff going on, and so does Stewart, but we're going to be doing more of these educational seminars on both the Constitution, active legislation, legislation that's already been passed that needs to be repealed, and other issues. Do you have any more pressing questions that you've seen, Dee, that somebody might want to address?
One person asked, well, how do you strong arm them? So let me discuss it real fast. You do that, like here in Montana, for example. Conrad Burns was a U.S. Senator, but Conrad Burns got away from the Constitution, and all the libertarians and the Constitution Party people and the hardcore constitutionalist Republicans abandoned him and just did not vote for him. He lost to John Tester, the Democrat. And so with Denny Rayburg, office contacted me and pointed that out. I said, look, you tell Congressman Rayburg he's going to be just like Conrad Burns once he fixes this. He has got to fix this, or I will make it my mission to make sure the same thing happens again. All the libertarians, all the constitutionalists will just not vote for him. He will not vote for an oath breaker. And so he's got to fix it. That's his only chance. Otherwise, he's running against Tester for the U.S. Senate. And so he knows in his cheapest that unless he fixes this, he's sunk. So he's been, he's been drafting bills to propose that we fix this. And so I'm helping them draft a good bill. So me and Richard are going to work on that and get back to him and say, hey, this is what you got to pass. Let's see you do it. And I told his chief of staff, it's not enough for him to introduce it. He's got to fix it. He voted for it. He helped put it in place. He has got to actually succeed in fixing it. Otherwise, he's done. And I'll make sure of it. That's what you do to them. You go to these Republicans and you say, especially the Republicans, and you say, look, you better fix this. I want you to be a co-sponsor of this bill, and I want you to actually get it passed. If not, we're done with you. It's a scorched earth policy. I'd rather have a bunch of Democrats get into office than to have traitorous Republicans who don't keep their oath. I'm done with it. I'm sick of it. Let's clean our own backyard up. We'll clean up the Republican Party, and then the Democrats clean their own party, too. And there's a lot of Democrats out there who are ticked off their congressmen and senators who voted for this junk, and they're going to challenge them in the primaries, too.
And on the members of the Congressional Constitution Caucus that voted for the NDAA, if you look at the screen, and I'm going to move it down in sections just so you can check with a quick glance, column D, these are all the folks on the Congressional Constitution Caucus that voted for this. You got to get educated and get informed. Well, thanks everybody for coming tonight, putting up with our technical difficulties. Instead, we're going to be doing more of these. And I see lots of God bless Americas and thanks Stewart. They say they wish they had a lawyer brother, citizens of South Carolina. It's nice to have lawyers you can ask legal questions to, but the founders wrote the Constitution for the common man to understand. And Lenoir County, North Carolina, was named after one of the members of the Ratification Convention, and he said that the Constitution should be understood by everyone. Even the most humble and trifling among us deserves to know upon which they stand. We'll try and give you more notice on the next one. Thanks everybody for coming and sticking with us through our technical difficulties. God bless you guys, and God bless America.